This is a lecture on character evidence. Now, character evidence is evidence of any conduct that the person engaged in prior to the events that you're trying to reconstruct. If I'm claiming this person ran a stop signs that they ran before this occasion, that's character evidence. Claiming they robbed a bank, banks they robbed before this, or anything else they did before this bank robbery, is character evidence. And the general rule is that character evidence, conduct before the event, cannot be used as evidence of what the person did in the event, at the time of the event. You cannot use my prior stop sign running to prove I ran this stop sign, my prior bank robberies to prove I robbed this bank. That is the general rule. But the problem is that there are a number of exceptions, and in those exceptions where you can offer character evidence, there are limitations on the form in which it can take, reputation or opinion. And we need to know about when can you use it, what are the exceptions. Now, character evidence is regulated by these code sections here, and we want to know what the law, what these code sections mean. And if we want to know what they mean, we need to begin with what do they say. And to find out what they say, I ask you to, at this time now, to go to Google and Google the Federal Rules of Evidence and print these 5 code sections, because these are the sections where you need to know what they say and what it means. If you just know kind of what it means, but you don't know exactly what they say, you can get burned. So please print these so we can talk about them. 403, FRE 403, 404, 405, 608, 609. So I'm going to stop for a moment while you download that. Now, assuming that you have downloaded these code sections I just referred to, and they're there for you to read, and I want you, as we go through, to actually stop and read them, because you'll increase the multiple choice questions in particular are aimed at not do you know kind of generally more or less kind of sort of what the rule was about, the specifics, what does it actually say? So get that rule and plan to read it. We begin with 403. 403 is a section that I'm sure you're familiar with that says evidence which is substantially more prejudicial than probative is not admissible. And what we mean by that is evidence which is substantially more prejudicial to your case, to you winning your case or winning your defense, substantially more prejudicial against you than it is probative of whether or not the evidence is truthful. Prejudicial against the case, probative of truthfulness. We're all familiar with this, but the reason I'm bringing it up now is for 2 reasons. One is that people get it turned around sometimes, and secondly, it comes up in 609, which we'll be looking at in a few minutes. Sometimes people say it this way on the board, that the evidence must be more probative than prejudicial. And this is not what the rule says, and it is not what it means. And this does not mean the same thing as substantially more prejudicial than probative. Let me make that clear. In the case of substantially more prejudicial, let me give you an example of this whole thing. I may have used this example before, but it's a good one. It's a real case in Arizona where a train had run over this person's arm, a freight train, severed the arm at the shoulder. And at the trial, the lawyer for the plaintiff came to trial one day and brought a long brown paper bag, pulled out of the bag this severed arm. It says, here's the arm, folks, and spattered a little blood on the jury. And in here, ladies and gentlemen of the jury, you can see right here where the shoulder used to be, where the train tracks are. Now, the jury can use that to prove that the train ran over the arm, the tracks are there. But don't you agree that the jury is much more likely to use that for sympathy? And sympathy is not an element in the case. And so the jury is much more likely to use that as sympathy than they are to use it as proof that the train severed the person's arm. And so when we say substantially more prejudicial, we mean like for example, something like 75% chance that the evidence will be used unfairly prejudicial. Not just prejudicial in the sense of hurting the other person's case, but unfairly prejudicial in the sense that you're using sympathy as opposed to rules of law. 75% chance, let's say, that they'll use it for sympathy, and a 25% chance that they'll use it to prove that the train really ran over the arm. Well, this is substantially more prejudicial than probative. Whereas if you go here, if you claim it must be more probative than prejudicial, which is very different, well, let's suppose it's 51% chance that they'll use it for its probative value and a 49% chance that they'll use it for its prejudicial value. Well, if you do that, this evidence is more probative than prejudicial. But that is very different from substantially more prejudicial than probative. So be sure to get it right, both because it comes up in lots of places, and secondly, because in particular, it's going to come up at 609 when we get there. Now that takes care of 403 over here. We understand what it means. We have an example of it. Let's now turn to 404. Now, 404 is the basic rule. And what the basic rule says is right here. Please read the actual rule, okay, not my summaries, not some other bar review summary. Read the rule itself. The bar examiners are testing the rule. Character evidence, the rule says in summary, is not admissible to prove conduct on a particular occasion. But there are some exceptions, and this is what's tested. You need to know the exceptions, and because there are circumstances where it would just be unfair not to let the person bring in character evidence to prove conduct on this occasion. For example, I am walking down an alley, dark alley, late at night, and somebody jumps out of the alley and they attack me for some reason. And we fight, and ultimately this person ends up dead, and I'm the survivor. And here it is, 2 o'clock in the morning, and the police arrived, and there's this dead body on the ground, and I got a stick in my hand that I hit him with last, and so I'm in trouble. I need you for a lawyer. And so what I would like to prove is that, look, folks, I am a very peaceful person. I don't start fights, never been involved with them at all. I'm a very peaceful person. And I would also, separately, if I can, like to prove that this victim is a very violent person. If I can prove either one of those cases, it will help my self-defense. Well, the only way I'm going to prove that this dead person was violent is by their prior conduct. The only way I can prove that I've been peaceful all my life is by my prior conduct. So you can see there are lots of situations like that where if I'm the accused, I need to offer my prior conduct as a defense. And maybe I need to offer the prior conduct of the victim as a defense. So you need these two exceptions here, that if I want to put on my good character, you got to let me do it. But if I put on my good character, the DA is going to be allowed to put on evidence of my bad character. Likewise, if I can put on the bad character of the victim, bad for violence, bad for whatever it is that I'm claiming the person did, that if I can put on the bad character for the victim, then again, the DA is going to be allowed to put on the good character of the victim as a defense. And so these are cases where you need an exception for obvious reasons. The other situation where you need an exception is the use of 608 and 609 for impeachment purposes. Suppose I am on the stand. You're my lawyer. And you're not my lawyer. You want to cross-examine me. You're on the other side. So you're going to cross-examine me. And you claim that I have no credibility. I'm not an honest person. How are you going to prove that I'm not an honest person on the stand without bringing in some of my prior conduct? Prior lies, prior something like that. And so in order to impeach somebody on the stand, you need an exception that you can use prior conduct to prove that prior lies to prove they lied on this occasion, prior dishonesty to prove I'm dishonest on this occasion on the stand. So, and likewise, if my prior conduct was a crime, okay, then all the more reason you may want to bring that to the attention of the jury. And so 608 is where my prior conduct is civil, and 609 is where most of it's civil. 609 is where my prior conduct is a crime. And so these are the exceptions, where even though you normally cannot admit character evidence to prove conduct on a particular occasion, that you can do it when the accused puts on their own good character, they put on the character of the victim, or you're trying to impeach someone. Now, so that's how 404A is used. 404B it also points out that character evidence now can be admissible if you're trying to prove something other than conduct, such as identity, knowledge, common scheme or plan, so forth. For example, there's an Arizona case. I wonder why everything happens in Arizona. There's an Arizona case where this person had killed his wife. And the way he killed his wife was he put an X-ray machine in the ceiling over her bed. And when they went to bed at night, he turned the machine on. And of course, she eventually died. Now, at the trial, one of the things you'd like to prove is that this person knew how to operate an X-ray machine. And if this person had been an X-ray tech in the military, you could certainly bring that in, says he knows how to operate the machine. Well, suppose in the real case, this person had killed his previous wife the same way, by the X-ray machine. And so if you bring in the fact that he had killed his previous wife to show he knew how to operate the X-ray machine, that's fine. You're not bringing it in to show conduct, but you can see how the jury in that case might very well say, well, if you killed your previous wife, you probably killed this one too. So the jury might misuse it to prove conduct on this occasion. So the judge would have to give a limiting instruction saying, ladies and gentlemen of the jury, you can use this killing of his prior wife, if you think he did it, to show knowledge of how to use the X-ray machine, but you cannot use it to show that, that he therefore probably killed this wife. So you can use prior conduct. Character evidence is admissible to prove things like identity, to prove knowledge, to prove common scheme or plan, those things that you see there in the code. I'm assuming you're reading the code. One more thing you want to pay attention to in that code section is that it says, if you intend to offer this kind of evidence for something other than conduct, but to show common scheme of plan, knowledge, that sort of thing, if you intend to offer character evidence for that purpose, then you got to notify the other side before trial that that's what you intend to do, so they can object if they want to. So that's how 403 is handled. That's how 404 is handled. 404 is the one that says this is the basic rule: no character evidence to prove conduct. With these exceptions, the accused can put on their own good conduct, in which case the DA gets to rebut. You can put on the victim's conduct, the DA gets to rebut, and to impeach. And then finally, 404B says you can use character evidence to prove this other stuff, which is not conduct, but other things. So that's how 403 and 404 are handled, and that brings us next to 405. Now, 405 says, look, there are some circumstances where you are permitted to show, character evidence. We just talked about them right here. Here's situations where you are permitted to show character evidence. If you are permitted to show character evidence, then in what form are you going to be allowed to present it? For example, if I am presenting character evidence of the fact that this person is violent, do I get to put on every fight that this person has been in to the jury? If I'm claiming character evidence and that this person on the stand is not honest, do I get to put on every lie that I know about that they've told? If I'm putting on character evidence all that sort of stuff. So the point I'm getting at is that if I'm able to put on prior conduct, if you let me put on separate witnesses and stuff for each of these prior conducts that I say was bad conduct, that character evidence, you can see the trial will go far afield. And so that's not practical. So what we do in that case is says, look, if you want to prove that this is a violent person, bring on their reputation, not their individual acts. If you want to prove that this was an honest person or a dishonest person, bring on their reputation, not their individual acts. And that's what 405 says. 405 says that whenever you are permitted to prove character evidence, this is the form it must take. You can prove the character evidence only by reputation or by opinion. Now, reputation, mind you, is the community opinion. This is the person's personal opinion. Reputation, you don't really have to know the person to know their reputation. If I, for example, I live in the same community with Joe, and Joe has been accused of a crime, and the question is Joe a violent person? And I go to the same barbershop. I don't know Joe, but I go to the same barbershop where Joe goes, and people talk about Joe's violence all the time. And I go to the same corner grocery store, and people talk about Joe's violence all the time there. And so you can see I know the community reputation of Joe for violence, even though I don't know Joe. And so I am permitted to bring on the reputation. Of course, you have to establish at the trial that I know this person's reputation. Okay? And so you point out that I live in the community and I go to the same bar. That's the basis. But once you've established the basis as to why I know the reputation, then you can put it on. Opinion. Now, reputation is the community opinion. This is the person's personal opinion. And the reason the federal rules put that in there to let you do that is because most of the time you put me on the stand and you ask me about the community opinion of this person for violence. Often what I really give you is my own personal opinion, if I have one. Because people have trouble distinguishing the opinion of others as opposed to their own opinion. So the federal rule says, look, people do this so much anyway, why don't you just admit it? So we admit the person's individual opinion. In the federal rules, the common law does not permit this. And on the bar exam, you'll get points for pointing that out. I've seen specific questions where the question turned, part of the question turned on this difference. So 405 says, if you're permitted to offer character evidence, then this is the form that it must take. Reputation under the common law or federal rules, opinion under the federal rules only. But here, if I am the witness on the stand and I say, I know this person's reputation for peacefulness. This person, Joe, has been accused of a violent crime, and I'm a character witness, and I say, I know Joe's reputation for peacefulness. I even have a personal opinion of Joe's peacefulness. And I tell you that Joe's a very peaceful person, and the reason I know the reputation is because of all of these facts. Now comes the cross-examination. You are the person cross-examining me when I spoke well of Joe. And you say, now Emerson, you say you know this Joe's propensity, his reputation for violence. Oh, yes. And I have a personal opinion. He's very peaceful. You say he's very peaceful. Oh, yes, Joe is very, very peaceful. Say, now, Emerson, did you hear that 3 weeks ago, Joe got into a fight in a bar and stabbed somebody 42 times? And I say, well, no, I didn't know about that particular fact, but I know Joe, he's very peaceful. DA says, well, Emerson, did you also know that 6 years ago, Joe shot 4 people at the corner barbershop? I said, no, I didn't know about that either, but I know him well. You see the point, that the DA is chopping away at my knowledge of, do I really know this person that well? And that's why the DA is allowed to ask me about these specific acts. But the jury is not supposed to, you can only ask these acts, first of all, if you have reasonable evidence that these things are true. You can't just make them up. If you make them up and I find out about it, we'll get a retrial, and you may have to pay for it. So so what this says here, and this is an important rule, that even though I can testify only as to reputation or opinion, on cross-examination, the DA can ask about specific acts. And they're doing this to see if I know the person that well, supposedly. 405B is an unrelated section kind of. 405B says, look, and we're going to come back to, let's not deal with 405B right now. We'll come back to 405B because it's so unrelated it will break the flow of our thought. So we understand 403, we understand 405, 404, we understand 405A. We're going to come back and deal with 405B. And let's take a look at 608. Now, 608 and 609 are about impeaching witnesses, impeaching them. And so the situation is that you got this witness on the stand and you want to impeach the witness. And as we mentioned earlier, the only way you can really impeach this witness is with some prior conduct by the witness. So if the 608A says you can prove my credibility, you can offer evidence of my honesty, my credibility, only after it's been challenged. If the other side doesn't say Emerson's dishonest, you do not get to put on evidence about what an honest person I am. Only if they've attached my credibility do you get a chance to rehabilitate me. When you put on evidence of when I've been attacked, and you put on evidence of my credibility, you can only use my reputation for truthfulness or opinion under the federal rules, but not at common law, as I mentioned before. 608B says, look, sometimes you can try to impeach someone by what they did. For example, if I got kicked out of law school for cheating, if I lost my license as a CPA for cheating, I wasn't convicted of fraud, but I lost my license. I got kicked out of medical school for cheating. And so you can see, if you can tell the jury that about me, that helps to impeach me. And so under some circumstances, you're going to allow these people to bring in this prior conduct that tends to impeach me. And so when can you do that? And that's what 608B is about. 608B says you can challenge or support my credibility by specific acts only if those acts are probative of truthfulness. Got kicked out of law school, got kicked out of medical school, lost my CPA license, and the judge, in the judge's discretion, says, yeah, you can do it. You got to get permission from the court. And that's basically what 608 tells us. 608, again, credibility. You can only support, you can't support a person's credibility unless it's been attacked. And when you support it, you're stuck with these methods here. Point out this difference between common law and the FRE. And then finally, if you're looking at the person's conduct, then the conduct, if you want to put that in to show that they are, to impeach them, the conduct must be probative of truthfulness, and you need to get permission from the court. And that brings us to 609. So they complete 608 here, and leaves us with 609. 609 is about the case where you want to impeach someone, and this time by conduct, but this time the conduct is criminal and there was a conviction, whereas in 608 we didn't necessarily have a conviction, or didn't have a conviction in fact. 609 we must have a conviction. 609 has an A and a B part, and 609A says we're going to decide now, when can you admit the prior conviction as evidence that the person is a dishonest witness? Once again, when can you offer prior convictions to show that the person on the stand is a dishonest witness? And you might say, well, gee, a lot of convictions have nothing to do with truthfulness. Somebody got convicted of involuntary manslaughter because they drove their car badly. There's nothing to do with truthfulness. And so there are lots of situations where a person can be convicted of a crime, but it really doesn't tend to bear on their truthfulness. Other situations, the person convicted of a crime, it does tend to bear on their truthfulness because of the nature of the crime. So how does the code deal with this? 609A says, here's the deal. You can admit prior felonies. Now, a felony is a crime for which the person, the punishment is 1 year in jail or more or death. And in the case of, those are felonies. So the 609A says you've got a witness on the stand now. It says you can admit the prior felonies of a conviction or of a witness if that witness is not the accused, because I'm testifying for Joe. Joe is the accused. That witness is not the accused only if it doesn't violate 403. Okay, now I'm on the stand and I've been convicted of reckless driving and spent 2 years in jail for it because somebody died, and so telling the jury about that probably doesn't violate 403. Is not going to be used unfairly because the jury realizes that being convicted of reckless driving, it doesn't have much to do with truthfulness. On the other hand, if I have been convicted of some other felony, any felony, they get to do this, but it's possible for me to create a felony where I got convicted. I'm the witness now, and Joe is the defendant, but even putting on my prior conduct may violate 403 as to Joe. Now, the way that would probably happen is if Joe and I had done something together, so that when you accuse me of a prior felony, you are in effect accusing Joe also. And I've never seen this tested, but you understand the principle involved. Secondly, under 609A, it also says that you can admit a prior felony of the witness who is the accused, that is Joe. You put Joe on the stand, and now you want to ask Joe about Joe's prior convictions, and now we got some tighter rules. The rule says you can ask Joe only if the evidence is more probative of Joe's truthfulness than it is prejudicial to Joe's case. Example, Joe is accused of this fight in the alley that I told you about. It's Joe instead of me, and Joe has survived this, and Joe is saying, I acted in self-defense, and I'm sorry this person's dead. And now Joe's being prosecuted. Well, it turns out that Joe was prosecuted for second-degree murder about 5 years ago, was convicted, went to jail. Well, now, if you bring in that second-degree murder, and the second-degree murder, by the way, happened because of the person's reckless driving. And so they got convicted of second-degree murder because of reckless driving, and and so now, I need to back up for a second. I don't have the facts quite right. In the real case, what happened is that Joe had been convicted of assault and battery, a number of years ago, and had stabbed somebody with a knife several years ago. And at this scene, Joe is accused of murder because the person died when they stabbed him with a knife this time. If you bring in the prior conviction of a fight with a knife where Joe went to jail over it, if you bring that in, that's heavily biasing the jury against Joe. It's going to heavily bias jury against Joe because they're telling Joe goes around killing people with knives. And yet, I don't know that if a fight in a bar with a knife is indicative of the person's truth, of Joe's truthfulness. And so the rule here says you can admit that prior felony of Joe only if the evidence is more probative of Joe's truthfulness, and I don't think a knife fight is very probative of truthfulness, only if it is more probative of truthfulness than it is prejudicial to the accused. And I think this is very prejudicial to the accused. It is very prejudicial to the accused because if you tell the jury about a prior fight that he got convicted of, and now he's being prosecuted for this when they're more likely to convict him. And so you can offer evidence that the accused felony only if it is more probative of truthfulness. Notice the way this is turned around. More probative of truthfulness than it is prejudicial to his case. And that's what 609A says. And finally, we come to 609B. And 609B says, in effect, that any misdemeanor can be admitted to impeach if it's one involving dishonesty, robbery, theft, larceny, perjury, any of that stuff. 609B has some other things in there that you should read. The one that gets tested, the other one, is the 10-year rule. That is to say, if the crime was more than 10 years ago, if it's been more than 10 years since either conviction or when the person got out of jail, whichever was the latest, 10 years from that date, if it's more than 10 years from that date, you got to get permission from the judge to bring in a crime that's that old. Now, that is how character evidence is handled. Let me give you a couple of examples that will be helpful. These are from real questions. If you want to see the full question, one is from the July 96 California Bar question. And in that question, a person who was a person named Fred, who testified on behalf of the defendant who was charged. The defendant in that problem was charged with murder. The defendant says, oh no, it was self-defense. And now Fred testifies on behalf of the defendant. And Fred testifies that Fred testifies about the character of the victim. Fred says, I have seen this victim start many other fights. Well, if you've seen the victim start many other fights, that is testifying to many specific acts. And you can't use specific acts here. You have to use reputation or opinion only. You cannot use specific acts. We know about that. And so if Fred testifies, I have seen the victim start many fights, that's not admissible because it is not reputation testimony and it is not opinion testimony. It's a collection of specific acts. If Fred had said, I know this defendant's, I know the victim's reputation in the community, and here's why I know it, and the reputation is that he's a very violent person, that would be admissible, but not many specific acts. From that same problem, there's another example where a boarding house manager, and the boarding house manager says, look, I am the boarding house manager, been there a long time and all that sort of stuff, so I know the character for violence of Fred, pardon me, of the defendant, and I know the defendant is a very peaceful person. Well, that's probably admissible. And then the boarding house manager goes on and says, and I have seen this defendant walk away from potentially violent situation. That's a specific act, okay? Not admissible. Reputation, opinion, not specific acts. And that is how character evidence is analyzed. We understand how 609 is used. That's how character evidence is analyzed, and the only part we haven't covered is the 405B part right here. Now, the 405B part, remember 405 says, if you are in one of these situations where you can admit character evidence, then you got to do it in the form of reputation or opinion, but the cross-examination can be like we talked about. But 405B says that you're not limited to reputation or opinion if this is true. You're not limited to reputation or opinion if character itself is an element of the crime or defense, or the claim or defense. And there are very few situations where character is an element. And you think about it, you can see that's true. You think about something like robbery, burglary, larceny. Well, you can't, the fact that this person has a prior history of anything, that's their character evidence, that's not an element of larceny. Previous larcenies are not an element of larceny. Previous anything is not an element of larceny. It's not an element of burglary. They may be the motivation, they may show a motivation of something, but it's not an element. And so There are very few situations where character itself or the person's prior conduct is an element. Let me give you a couple because you can see how scarce they are. One of them is in child custody cases. So the man and woman are, arguing over who should have custody of the child, and one parent says, I'm the gooder parent because when a child's with me, I take him to the zoo and I take him to educational things and I do all these good things for the child. And the other parent says, oh, I'm the better parent, I'm gooder than they are because when I have the child, I do all these good things with them. And so you're using their character of what they do when they're with the kids, prior conduct, to decide who is the better parent. So character evidence is actually an element that is considered in the case of child custody cases. Another example is in negligent entrustment cases. There's a case on the bar exam where I'm a parent and I let my 10-year-old kid play with a BB rifle. And my kid had a reputation of being a bully in the neighborhood. And the kid shot some 4-year-old in the eye with the rifle. Well, and I'm sued for negligent entrustment, civil sued for negligent entrustment. And so in this situation, if I knew the character of my 10-year-old kid as being, abusive in the neighborhood, if I knew that character trait and let him use the rifle anyway, that is negligent entrustment. But if I didn't know about that, it's not negligent entrustment to let an ordinary 10-year-old kid have a rifle, a BB gun, not a real rifle, but a BB gun. And so whether or not what I did when I let the kid use the BB gun, whether or not that is negligent entrustment depends on whether I knew about the kid's character of being a bully. So those are a few situations where character itself is an element. Most of the time, it's not. Very rarely is it. So that's how character evidence is handled. You understand what 403 says, that substantially more prejudicial than probative, not admissible. 404 says character evidence is generally not admissible to show conduct, but there are some exceptions. 404B says character evidence may be admissible to show stuff that's not conduct. 405 says if you're going to admit character evidence, and you can do reputation or opinion only, but the cross-examination can be on specific acts. 405B says you can use specific acts to establish character if character itself is an element of the offense or whatever it is. And it's not very often that character is a part of the claim. It doesn't have to be a crime now, part of the claim. 608 is about impeaching witnesses. You can't support your witness's credibility until after it's been attacked. And when it is attacked, you can support it with opinion or reputation testimony. That's 608A. And 608B says that you can also attack or support a witness's credibility with specific acts. You normally can't do it with specific acts, but you got to use reputation or opinion. But you can use specific acts if the specific act is indicative of truthfulness, such as got kicked out of the bar for cheating, such as any act such as that, and lost my CPA license for cheating, even though I wasn't convicted. So I can offer evidence of character of specific acts, like getting your license revoked. I can offer these specific acts if I get permission from the judge, and those are acts which tend to show truthfulness. And getting your CPA license revoked does that. So that's what 608B allows, specific acts in those situations. And 609 deals with the cases where there's been a conviction, and if it's a felony, felonies come in, but they have to meet these requirements. If it's a felony of not the accused, 403 limits it. If it is the past felony of the accused, then the evidence must be more probative of the accused's dishonesty than it is prejudicial to the case that the accused is offering. And you can see in that hypo that if I stabbed somebody with a knife and they died, and the jury is told about another knife fight I had a few years ago, that that's going to be very prejudicial to my present case, because I had this knife fight and hurt somebody then. Very prejudicial to my present case, and a knife fight is not very probative of truthfulness, and so it might not be admitted. That's how 609A and B, 609B is the one that says if it's a misdemeanor that has something to do with dishonesty, admit it. You also got the 10-year rule there and a couple of other things. And that's how character evidence is analyzed. Those are the rules. If you know those rules and use them, you should do very well. And that is the end of this lecture.